Hello, everyone, and welcome to this webcast by IVCA. Thank you for joining in this Tuesday evening. I do hope you and your near ones are safe and sound, but equally important, are taking all precautions so that that status of safe and sound does not change. Indeed, I'm presuming everybody on this call is in that protected lot where lives and livelihoods are both protected. And as someone said, work from home does imply that you have both the components in that phrase, work and a house. So with that blessings, let me dive into today's agenda. India does have hordes of rulings coming out every day across various tribunals, high courts, and Supreme Courts. And for those who are not tuned into this issue already, you may be wondering why is it that IVCA is hosting a webcast on an order which was passed maybe about 9 years ago almost, in respect of a law which is not even operative today. And the answer to that lies in the fact that this ruling has the impact of not just the limited area in which it operates, but as we will understand as we go along with this webcast over the next 45 minutes, an impact beyond service tax, beyond indirect tax, and if I may add, beyond tax itself. I'm not going to spend time in introducing IVCA, but I must let you know that you're probably aware of the quite a wide piece of work that this institution has been doing. Having been personally involved with some of the initiatives, including the advocacy initiatives, even things like what we take for granted now, the whole AIF taxation piece, where IVCA very closely worked with the regulators in order to make sure that we get to a tax system which is uncertain, clear, and enables all of us to do what we want to do. So I'm going to straight away introduce the subject matter experts that we have with us today, who over the next half an hour or so will take us through. We have left time at the end for question and answer, and I'm sure you will be having those. I have with me three subject matter experts today. Prateek Jain, who needs no introduction in the field of indirect taxation. And with him, Niren Sethia, who has a lot of experience specifically on dealing with indirect tax issues as far as this industry is concerned. I also have Sameep Barlota, who has years of tax and regulatory experience on this sector, more focused on the, if I'll say, non-indirect tax side, the rest of the tax world that we live in. And with that, let me hand over right away to Niren, who will take us through what are the technical aspects of this ruling. And may I remind you again, this is one of those rulings which is not just intended for analysis, but has been summarized in the end for action as well. Over to you, Niren.
Thanks, Gautam. Good evening, everybody. And I also wish everybody is safe and sound. In the next half an hour or so, we'll be discussing these aspects around this decision. What is the issue? How they have gone about computing the demand, the findings, some aspects which are relevant in the matter, some open issues or the impacts around this decision. How is the world looking at this issue, and what is their perspective or their outlook, and some questions or some open points which will be there at your end. This is the large agenda. Going into the issue, before I discuss this, and this is a typical structure, some relevant points to understand. The demand in this case is for the period from 2005, 2006 to 2011-12. It is a service tax demand, and it is in the period where it was in the pre-negative list of service tax. So that's the relevant from the perspective of the matter. A typical structure which is there, wherein there are Class A investors, and Class B, C investors, depending upon the structure. Uh, and on the normally what the fund would do, which is having expenses in the form of management fee, trusteeship fees, or other expenses, is the normal structure. The fund invests in portfolio companies and as it returns. The entire matter which the department has alleged in this present case is that where the world at large or the industry at large feels that the fund is a pooling vehicle and is just for the purpose of pooling the money or the investments and then investing in portfolio companies where the entire operation is undertaken by the manager. The department sees this differently, and the department feels that this is something which the fund itself is the entity which is a service provider, and they are providing a service to the contributors or to the investors, and hence to that extent they are performing services, and hence accordingly they are liable to a tax, to be precise, service tax presently. To go about determining how the computation of demand or the manner of demand or on what amount should there be service tax payable, uh, they have the basis of allegation or the basis for them is that all expenses incurred or amounts retained out of what contributors have contributed, whatever you have retained, and you have then spent in it in for expenses or uh, for payment to nominee companies or to class B, class C as distribution. To that extent, it will qualify as an income for you to be in this business of fund management or asset management, and hence that's the way they've gone about. To give more clarity in terms of how the demand has been computed, we've just tried to make a simple example. Uh, so the total demand in the present case is approximately 321 crores. It is divided into two buckets. The first bucket represents expenses which are normally incurred. You'll observe that one line item over here is also as loss or impairment of assets. They have even included this amount in in seeking to quantify the demand, and saying that all these expenses which have been incurred by the fund is arising out of the amounts retained out of the contributors, and which will qualify as the gross amount charged or the consideration for the services. And hence the first bucket of demand is 277 crores. The second bucket of demand is coming out of the distribution made uh, to class B, class C investors. It could be the investment manager, it could be its nominees, and they have gone about to say that the entire the objective of for the fund to be in this or the trust to be in this activity ultimately results in distribution to its nominees or to investment managers, which are all associated, and hence all of this will also qualify as consideration in the hands of the fund, and that amount is 54 crores, totaling to a total demand of 321 crores. So this is the way they have gone about the quantifying the demand. So going into the various aspects or the findings of the tribunal. Before that, it's important to understand, what was the facts, or what were the submissions made on both sides. The As I said, the department is looking at it from the perspective that the fund is a service provider, and hence it has tried sought to, in the show cause notice and in the order of the commissioner, it has uh, sought to establish that the fund is in the business of long term investment management. It has a systematic approach whereby it is pooling in money and then returning those money in the form of interest or dividend. Hence, it is doing a sort of an activity which is in the nature of an asset management activity, thus trying to come to a conclusion that it is a service provider and the service receiver are the contributors or the investors who have invested in the fund, thereby trying to indicate that there is a existence of a relationship of a service provider service receiver. The appellant in this case has has made exhaustive submissions to bring out that how there is no relationship of a service provider service receiver. The thrust of the argument is around the existence of a mutuality, like the way it is being seen and being acted upon by the industry, that the fund basically is a pooling vehicle. It is not acting in the capacity of a service provider service receiver. It is not having any employee as such to perform services, and the entirety is actually being done by way of the investment manager. However, the tribunal sees it differently, and what it did was it has gone into the aspect the fund documents, the PPM, and it observes that it is actually a independent commercial entity. The It is doing this long-term investment planning, and it has a motive of profit. On this profit motive, it has actually there were a lot of submissions made that it is similar to a club where there is an association and there are members, and all the expenses are incurred on behalf of, or everything is done for the members. Whereas and there were a lot of submission, there were few judicial precedents on this ground that club and members there is an existence of a mutuality, and hence there is no service provider service receiver relationship. However, that those submissions were distinguished on the ground that there's an existence of a profit motive, and as soon as there is an existence of a profit motive, the fund and the members, or the fund and the investors, cannot be treated as there's an existence of a mutuality between them, and hence it is a service provider service receiver. One more aspect which they uh, examined, or they found, was that the fund had taken registration under various laws, for example the SEBI, the income tax, and the trust act. Hence saying that as soon as you are taking registration under various acts, it indicates that you are a separate person, and hence to that extent there is no mutuality between you and the investors. In this decision, they have also gone about to say that they are separate for the reason that you undertake KYC for the contributors or the investors. As soon as you do KYC, why would you do KYC if you all were all one? That you are treating it separately, hence you are doing a KYC, and they have held that as one more reason as to why the mutuality does not exist. There were submissions made with respect to mutuality and that non-existence of service provider service receiver relationship, and the aspect that there's no consideration in the hands of the trust to or the fund to do this fund management activity. However, as I explained, that for the purpose of consideration, they have said that amounts retained would be deemed to be consideration, and gross amount charged for the doing the activity. And to further establish the point that there is a service provider service receiver relationship, they've gone to the extent of comparing it with a bank providing services to its customers. Hence fund management, asset management, long term uh, asset management, long term capital investments, systematic method of pooling in money, and then returning it in form of dividend interest, were all of these reasons where they felt that doing so many activities are actually commercial activities, or having a commercial it's a commercial concern, and hence to that extent it cannot be treated as a trust, or an entity which is not in doing commercial business. uh, one more point which they have given a finding is on carried interest, where they have given a finding on the point that it is in the nature of performance fee. The one very important point to be understood over here is the entire demand is from the perspective of the fund. There is no finding that service tax is payable on carried interest. What they have said that carried interest is being paid to the nominees or to the investment manager, which is a part of the structure, a part of a structure which is specifically being put in place to give benefit to the companies within the association, and hence uh, all distributions made to for such performance activity. So they have given a finding that's a performance fee, but the performance fee is being given to one of its nominees or the investment manager, and hence it's a mutual interest, and accordingly they have gone about saying that the structure is a facade, and so all the members they have treated as one, and accordingly they have said that to that extent it is also a retention of money from the contributors, and to that extent it is liable in the hands of the fund, not as a performance fee, but just because it's a retention of money by the fund from its contributors. Uh, they have also made exhaustive, there is exhaustive finding, and there were a lot of submissions made by the department that there is a lot of disproportionate income, and accordingly this disproportionate income indicates that it is not in the nature of return on investment, which was the thrust of the argument or the basis or which are the strong arguments made by the appellant, that these are all return on investments. However, there was a finding given that it is not in the nature of return on investment, but it is basically a performance fee. There were other submissions also made, like revenue neutrality, uh, credit should be allowed, because now if you treat this as taxable, then I need to be even granted the credit which I have paid of taxes for so many years. Uh, at the relevant point in time, there was no limitation as such in law for availing credit. However, now today there is a limitation which comes in because of post 2012 limitations. Well, sorry, post 2014 there were limitations in the law for taking credit, and in GST again there are limitations. Hence, those limitation aspects will also be have to be considered going forward in terms of availing credit. Cum duty benefit, a common concept under the indirect tax law, which basically is giving grossing up of tax, simply put, and that benefit of grossing up of a tax should be given. All these, so credit was allowed, cum duty benefit was allowed, and interest penalty has been imposed. The matter presently has been remanded to the lower authority for recomputation on account of amount of credit available, the benefit which will come arising on account of cum duty benefit and other impairment of losses and all, which are not in the nature of expenses. So there has been a remand to that extent, which the lower authorities will have to examine and again pass an order. One critical aspect which is relevant to be understood, that this issue is related to domestic funds and is only to the extent which the impact of the decision is. Uh, when we look at this entire matter, there are many regulatory aspects and concepts which are relevant. They have been argued at length by the council. uh, However, it has been rejected. They have gone to the extent to say that the structure is a facade. The trust should not be treated as a trust to the extent of taxation matters, and such kind of findings seem questionable, especially with the structure being a SEBI approved structure. It is set up as a trust and governed by the Indian Trust Act. Uh, the structure is required from the perspective of investor protection, and hence there is a need for such structures. Uh, it is fund is a pooling vehicle, and most importantly, investors expect return on investment, not services, which is being the primary objective for the investors to invest in through the fund. These aspects are going to be very critical, and these aspects are going to have a significant bearing in the outcome of the matter as this matter proceeds further in the appellate forums. So these were the key findings or the outcomes of the decision. I'll now request Sameep to take over from here in terms of the uh, the global footprint of this matter and how it is seen globally. Uh, as Gautam mentioned, any questions revolving around any aspects, please feel free to ask it in the chat box, and we will take them at the end of the session. Yeah, thank you. Yes, Sameep, over to you. Oh, I'm sorry. I'm sorry. Sorry, Pratik. Pratik, you will have to come in over here. Extremely sorry.
Sure. No, thanks, Niren, and good evening, everyone on the call. I think Niren has set out very clearly about the ruling, the factual parts of it, and what were the submissions, what were the counter submissions, etc. Obviously, there are a lot of technical and interpretation issues involved in this. I think we are, in a sense, industry is slightly lucky that the kind of decision which has been issued, there are a lot of apparent loopholes in that they have not made out a case properly. And you will see a disconnect. On one hand, they're saying this entire structure is a facade. On the other hand, is saying that there is a service being provided by the fund to the investor. There is an inherent disconnect between these two. But be as it may, I mean, the question really is that what is likely to happen now in next few months, maybe a few years as well. So clearly, this decision is something which has now come, and DGGI, which is the investigation wing of the government, this decision is while it is in context of service tax, the context, the overall context remains the same. The law, the structure remains the same, and the GST as well. So chances are that the DGGI will start looking at this and start doing some investigations. They perhaps reach out to more funds, fund managers, and so on and so forth. As a practice, they invoke a larger period of limitation. That would mean that they can potentially go back up to 5 years from today for looking at this. So therefore, the exposure in that sense remains from 2016 as we stand in 2021 right now. There is, of course, while Niren did point out that there is no specific finding, so to say, about the carried interest, in a sense that this was not the issue per se. They have just said that all the expenses of the funds are liable to service tax in that context. But I think there is a strong likelihood that they would start looking at the carried interest component specifically, and whether it is liable or not, and whether the return that I'm getting as an investor, to what extent it is attributable to my service, and to what extent it is on account of investment. Sale of securities, of course, sale of shares is exempt from GST. It's not liable to GST, and therefore the basic disconnect still remains that if I'm treating this as sale of security, and hence it is capital gain in my books, then whether on that same amount you can also impose GST. And I was just looking at one of the questions which was asked, and we perhaps will take it later. But the question was that what will be the income tax implications of this, and does it automatically mean that I can't treat this as capital gain and will become my business income? And some of those things will of course need to be looked at. The decision per se will not apply automatically to income tax legislation. Of course, based on this, the income tax department may initiate a separate proceedings. But obviously, automatically, it does not apply an income tax law as well. And therefore, there is a basic inherent disconnect that I was talking about. The question still remains. I mean, now a lot of questions, and this decision is sort of leading to more questions than answers, of course, that whether as fund should we get registered? Because if there are timelines for us to claim input credit, and this is for GST, it is September of next financial year, then if I don't claim it now and I don't take registration, then tomorrow if there is a liability or if there is a demand against me, can I go to court and say, well, in this decision, the CESTAT has been kind enough to say that, okay, you can claim the credit, but then it becomes the discretion of the court to then say that, okay, fine, while you're not paying tax on your revenues, but you can claim input credit. That will become a discretion of the court, because you'll have to challenge the law per se. So one point that we need to put up deliberate is that is it time for us to take registration and claim ITC, at least in the books? When I say ITC, input tax credit, in our books, what happens to some of the expenses which are exempt? And one of the points that Niren did mention about revenue neutrality, one of the argument was that most of these expenses with the fund incurs is already subject to service tax at that point in time, except for the carried interest component of it. And hence, if you are taxing it again, it is a revenue neutral exercise, right? Because you are eligible or you're allowed a credit. But what happens if the expense is per se not liable to GST? And in that sense, it become additional 18% cost for the investors ultimately. Investors' outlook, of course, if this has to be taken to full force, although this decision, as I said, seemed to have a lot of loopholes, and of course, when we go into to court, I think we should have a more than reasonable chance of success as far as this decision is concerned. But ultimately, if the government wants to tax it, then there is 18% additional tax, at least on the carried interest component. And because rest of it was anyway being subjected to tax, most of the expenses. So what does it mean from an outlook perspective? One will have to see. And more importantly, similar concepts are there for mutual funds, other funds as well, and other tax laws. I know Gautam did initially talk about that this will translate into other laws beyond tax as well. So there is, of course, an income tax play. But if the observation is that the whole structure itself is a facade, then what happens to other regulations, right? So this decision has ramifications, which is much beyond the GST piece or service tax piece that we are talking about. So a lot of things for us to kind of look at, and as we sort of interact more and answer some questions, we will talk about some of the practical aspects of it. And with this, I'll maybe pass it on to Sameep to just talk about, give you a bit of a global perspective, because of course this structure is not new, and this is there globally similar structure is adopted. So what happens globally, and then we can come to the Q&A part of it. So Sameep, over to you.
Yeah. Thanks, Prateek. Trust everyone is keeping safe, and good evening, everyone. I think before we get into the fallouts of the tribunal's decision, it's just important to give a fresh perspective or a step back in terms of how one could look at carried interest. And the best way to look at it is in terms of the overseas jurisdictions, which are popular fund management jurisdictions. How have they treated carried interest as akin to? So if you look at this slide, a lot of these popular fund management jurisdictions, be it US or UK or the European jurisdictions, as well as the Asia fund jurisdictions in the form of Hong Kong or Australia. I think most of them have recognized the difference in treatment for carried interest given its peculiar nature, and come up with specific circulars or regulations on how to treat carried interest. They have come up with these guidelines which say that carried interest is akin to investment income if it satisfies certain conditionalities based on the circulars and all. And some of these conditions do throw light on the unique nature of carried interest. The tribunal has stressed on the fact that the carry units lead to a disproportionate return, and hence it is giving rise to service fee. But if you look at it from a fresh perspective, how these jurisdictions have looked at it, what they say is that it's more akin to a profit share. So what gets granted or allotted upfront is a profit share, which is based on future profits. It's not a fixed fees or a fixed income which is intended to be given. It is a profit share which is given upfront, and there is a contingency attached to those profit shares. So to that extent, that is one of the conditions. So if you example see UK, Australia, and Hong Kong, they specifically have this condition of it being a profit-linked contingent return. Some of these jurisdictions like US and France have imposed a period of holding condition. So if you hold the units for a period of 3 or 5 years respectively, they treat it as akin to an investment income. France, for example, also has one condition which lays down that a particular minimum amount of subscription which the carry holder has to put in to qualify as investment income. So in India, we have similar regulations where the sponsor is required to put in a minimum contribution to form a local AIF. So similar, I mean, concept, I mean, in terms of skin in game is prevalent in India. One more aspect is that the Finance Act 2021 has recognized the units of AIF as akin to a security. And as Prateek alluded, that GST does have specific exclusions in terms of securities not qualifying as goods or services. So whether one can look at it more akin to a security which operates on a standalone basis with predefined profit share being put in, and hence the ongoing investment, ongoing income is more income arising from a security rather than service fee. So I think that's what is something which some of these global jurisdictions have recognized and come up with a specific regime to provide clarity to the fund managers. Uh, India has been encouraging fund managers to come back to India. Last 2-3 years, we have seen a lot of effort put in by the government with due representations from IVCA and the industry to make India a good jurisdiction in terms of onshore fund management. Be it safe harbor rules for India managers managing offshore funds, or financial services zone where the funds and the fund managers could be relocated. I think this should be the next topic where the industry has to come together and give a robust representation, as well as for the Indian government to recognize the peculiarity of the concept and give it the due treatment in line with the global standards. We can move to the next slide. Yeah. So uh, now, as we stand today, obviously clarity is some time away, and the fund managers have a situation at hand in terms of taking various decisions. It's early days. I mean, the tribunal decision has just come. So obviously, some matters have been remanded back to the assessing officers to determine the factual positions, and obviously the decision will get appealed against, and the courts will take their own course of action. But I think as fund managers stand today, there are various things one can do to just I mean, look at it from a fund manager perspective. The first is obviously the clarity on the tax position to be taken, and while the industry will have to make representations on this topic, I think it is worth a relook at the fact pattern of each fund manager in terms of various parameters, be it the documentation in the agreements, the disclosures which have been made in the financial statements, the contribution amount that would have been put on the units, as well as the timing of the allotment of units. So one needs to look at all these factors and just see where the fund managers stand if this decision was to be applied as is. Quantum of tax, again, the decision is has opened up quite a bit of nuances on computation in terms of going after expenses, impairment, apart from carried interest. But obviously, one has to look at it from a overall perspective and look at the quantification on a rational basis, as also any potential interest and penal obligations. Uh, there there are certain situations where the fund has been closed. In the past, the fund managers may not have looked at this particular issue, given that more or less the industry was treating it as akin to an investment income in line with the global standards, and hence the documentation may not specifically deal at times with the aspect on who bears this cost. So specifically where the funds have been closed, or they are up for liquidation, where the last few investments are there. The fund manager has to take a conscious decision in terms of any reserves required, which again will go back to the fund manager's analysis of the documentation and his own facts. Lastly, in terms of the new funds, again, I think with this decision out, there will be new funds will have to specifically provide in their documentation that if there is any such taxes on the fund, they would be recoverable from the fund or the investors, as well as, I mean, if there is a position being taken that GST is not leviable on these amounts, if there is a requirement to indemnify, that also gets provided in the fund documents. So fund managers need to just evaluate this decision the way it is, and ensure that as a fund manager they take some of these decisions on a rational basis. I think with that, I'll hand over to Gautam for the closing remarks.
Yeah, thanks, Samir. So, friends, you heard, like I said, over the last 30 minutes, Niren, Pratik, and Samir not just explain to us technically, what the decision says, but the more wider ramifications under service tax and GST law. And as Samir pointed out, some very immediate practical impact or action that is required to be done. At your end, it's a question of looking at what the commercial arrangements are. It's a question of looking at where funds have been closed. Is there a need to review what's the positions taken there? And while one may decide, or one may think about adopting an ostrich stance right now, let things come to me and then I'm going to act. And obviously, this decision will take time till it reaches finality. The risk, obviously, here is that on the back of this judgment, as Pratik alluded to, there could be other actions being initiated by the government, and rightly so. If that's a decision that's come out, one would expect that the government would probably take some further action on that. So clearly, risk analysis of your existing structure and documentation, and we've seen this differs from player to player. Evaluating different options, they could be risk mitigate. Advanced ruling has been proposed and is in the law, the structure, but whether that merely facilitates an early resolution of the dispute or otherwise, I think is a matter that needs to be thought through. Clearly, GIFT City is an area where we are seeing a lot of players setting up shop. How would this play out in the context of a GIFT City fund or a GIFT City manager? You may be aware, on a related note, that the Income Tax Act got recently amended by the budget to say, as far as the safe harbor rule is concerned, which permits an Indian manager to manage an offshore fund from India, there are expected to be some relaxations if this fund manager is located in GIFT City and not, say, in Mumbai, where I'm speaking from right now. So would that in any way help in mitigating the outcomes of this decision, assuming the outcomes are not favorable? Clearly, representation of the government, a lot has been said about, and I will give a slightly broader perspective. I said it's beyond tax. Friends, we are in a post-COVID world, especially at this point of time. It's critical that we enable not just fundraising and fund deployment. And in that context, it's important that India as a country remains competitive. I could take away three things that come in the way of our continuing to be competitive. One, obviously, is about the rate of tax. What are the financial implications if this were to be the interpretation, and if this were to extend the principles that are kind of alluded to here, were to extend beyond GST and into the income tax scope as well. So that's about the financial implication. There's a piece on uncertainty. Obviously, there is going to be some amount of time before law takes its course and one gets the final outcome of this ruling and the principles that are being sought to be propounded under that. How does one live in this era of uncertainty? And thirdly, it's about a potential impact on the past, a retro impact. To me, each of these three things take away India's competitiveness and the ability of funds here to be competitive with their counterparts and peers across the globe. And I think it's in that context that the discussions would need to be undertaken with the government to just get them to see the larger picture, and obviously, leveraging of best international practices without necessarily, compromising too much on the revenue perspective that will be there. So clearly, I think that's the way forward. I did say this is not just analysis but action, and please feel free to reach out to your connects in IVCA or to any of us if you have additional thoughts about how this representation can be taken forward and made more robust. Let's pause now and spend time with you on the Q&A that you have raised. So, Sameep, Niren, would anybody be taking up the questions and directing it to the right folks?
Niren, you're on mute.
Yeah. I'll just go about. So there have been a lot of questions, and I'm just going through them. So there's some which I'll just take up, and while I'll just respond to some while asking others. So Pratik, there's a question around from here, what does it look like? Will it go to High Court or Supreme Court? And according to you, what are the timelines which seem broadly in terms of this litigation?
Yes. So look, I think from the decision, it seems that one will have to take it to Supreme Court clearly, because it's a question of taxability. While there are other observations around that, but essentially it's an issue of taxability. Should go to Supreme Court. Of course, right now in a pandemic kind of a situation, courts are functioning in their own way. Anything which goes to Supreme Court takes years before it reaches finality. First course will be an issue of admission, but once the matter is admitted, it will take its own time. And I think what we need to do clearly is, apart from the litigation, which will take on time, 4 or 5 years at least, if not more. What do we need to do now, right? For further things, what do we need to do on the documentation front? Representation, which Gautam talked about, and on what grounds do we do the representation? Once we do the representation, also bear in mind that the issue of penalty is avoided, because you have reached out to the government, and then the government cannot say later that, look, I didn't know about this issue. So I think that's also an important aspect for us to kind of look at. So long haul, I guess one will also need to do a little bit of more deep dive into the risk assessment of the carried interest part, and maybe try and sort of see if one believes that risk is high, then do we need to change the structure of that as well, right? So I think a lot of things to be done, but of course it will take time as far as closure of litigation is concerned.
Yeah, and a connected question to this: do you think now funds should get registered in GST?
Look, I mean, very difficult to give a yes or no answer. I think it will depend on the risk assessment part of it. There are people who in this kind of situation take registration, claim the credit in the books because to meet the timeline. But once you take the registration, of course, you file. Let's say if you file nil return, depending on what the government is likely to do. Any case on investigation, does it mean that you've taken a registration and it's your admission that you're liable to pay tax? So if you take a registration, do you need to file some kind of an intimation or a letter with authorities to say that you are just taking this registration to meet the timelines of input credit? You believe that this is not taxable. Some of those strategies will need to be looked at. But yes, that option needs to be evaluated. But along with that, what else do we need to do? As we proceed further is the question.
Incidentally, one more connected to this is the question that there are now, assuming somebody is taking a registration and there is a demand for the past. So we did cover in our discussion. The point was, what about the past credit? And what are your thoughts or views around that? Will there be relief around those points?
Yes, so in this CESTAT decision as well, they have said that you are under the impression that your services are not taxable or these are not services, and hence now if the government is saying this is taxable, you should be getting credit for the past period. We have also seen in GST, at least there are a couple of High Court decisions which have come on in context of real estate more recently, where they have said the issue was on credit on construction expenses, and the grounds were that it should be allowed. And they said that, okay, right now the government is saying it's not allowed, but tomorrow if we were to decide, High Court has made a specific observation that if we were to decide that it is allowed, then the time limit for claiming credit will not be like September of next financial year, right? They said that it could be the time limit will not apply. But in that case, you have challenged the law per se, right? So in each case, you'll have to you'll have to see how the bench is and what the court decide. There is very difficult to say that whether they will agree with this High Court decision in all cases or not. But I would say that there is a good, more than reasonable chance, to my mind, that you should be able to get the credit even if eventually you have to pay tax on output.
Okay, Sameep. So what the question is that, is there anything to worry about for overseas fund structure where only sub-advisory entities in India?
No, I think this decision is more on the local fund management. So offshore fund management doesn't get impacted. Neither does the safe harbor fund management, where the funds in India, the managers in India are managing an offshore fund or the IFSC fund. So neither of those get impacted because either it's an export or there's a specific exemption in relation to the IFSC fund management.
Okay, so connected question is there.
If I can just add over there to what Sameep mentioned.
Yeah, please go on.
It's a great question, right? So as Sameep mentioned, this is not applicable if funds are overseas or fund
Can
managers.
You speak a little louder? Gautam, can you keep your mouthpiece near? Yeah.
Is this better?
Slightly better, but it can be better.
All right. So go ahead with your next question. I'll try and fix this at my end.
No, now we can hear you, Gautam. Please go on.
Yeah. So the point to remember in terms of representation is that, are we making managers based in India, forcing them to think that is it better if I were to relocate overseas? And that's certainly something what we do not want as a country. So I just wanted to bring that perspective as well, and I think this is a great follow-up to this question. I recollect the other question about income tax as well. Somebody asking does it have impact tax? So obviously this is a decision by the CESTAT. It should not, or legally has no impact on income tax. But because it has gone and given a different perspective to certain fundamental principles on how we understand and the industry has practiced economics and structures, this could throw up questions in other parts of the law to say, well, is this LPGP? Is it a partnership, or is it a return for services? And if one gets into that question and takes a stand similar to what is alluded in this judgment, then clearly you will have a lot more issues opening up on the income tax front as well.
Thanks, Gautam, for sharing. So there is a question connected to global impact in terms of whether globally GST or VAT is being paid on carried interest. To the extent of our limited research, which we could do in the past few days, we've learned at least in these jurisdictions where there has been a clarification, there at least it's being treated as return on investment subject to conditions, and in those jurisdictions a VAT or a GST is not being paid on their income as performance fee. Similarly, there is a question around whether the units of carried interest were allotted to AMC or to the employee EBT or employee benefit trust. And the question says that the CESTAT order is unclear. Even I would say the CESTAT order is unclear. Just that there is a passing reference that it says that it has given to nominees also, and hence what comes within those nominees we don't know, and whether it covers EBTs or it does not cover EBTs, not clear. But that's what they were trying to say, that even nominees are covered. And hence your question, a corresponding question which is there, that if it has been held by a EBT, what will be the implications for them? Coming from the decision perspective, the way they have seen, and if you say that it gets extended to nominees, they're trying to they're trying to give the similar implication, which is that all of that would be treated as provided to for a beneficial interest, and hence would be taxable in the hands of the fund manager. However, what is this nominee and what to extent it covers, not clear. Like we know, in this present case, there were 11 funds, and the structure of the 11 funds is not coming clearly in this decision. Hence, not clear even for us to respond to this question in that clarity. Pratik, sorry, not Pratik. Gautam, a connected question for you. Uh, if you see, look at the decision which has been issued, it is going to the extent of saying that, uh, you know, from a tax perspective or a GST perspective, it is liable, one, and the structure is a facade, or the trust is not there, and it is not to be treated as a trust from a, at least from a taxation law perspective. What do you think, that how would the appellate forums, the High Court or the Supreme Court, look at all of this, and how will they give the significance of all these structures or all these legislations to the extent of this matter?
Yeah, Niren, good question. And I'm just doing a sound check. Hope you can hear me. Okay.
Yeah,
Yes,
please.
Yeah, there have been, I think, enough instances under Indian jurisprudence where courts have looked at the regulations under which these kind of structures have operated. One immediate one which comes to my mind, not in the context of service tax, but in the context of income tax, there was always this question of whether foreign portfolios investors, their income is in the nature of business income or capital gains. And I recollect that ruling. It went to the FII, SEBI FI regulations, went through the intent and said the idea is to register investors under this regime. And therefore, that led them to the conclusion of saying this should be investment income. Like this, I'm sure we can come up with enough and more instances where the impact of regulations under Indian law have been considered and respected while giving or adjudicating on tax matters. So as you all have mentioned, I think that element of the fact that this is a structure blessed by SEBI, registered with SEBI, going under the regulations themselves require the manager to have some duties, the fund itself to have some duties and responsibilities, which is not, as I could recollect under VCF regulations, of providing service. Right? I guess all of these factors will or should be considered by the higher courts at some point of time.
Thanks, Gautam. So there is a question which is saying, what is the next action for this decision by CESTAT? In most likelihood, we believe that it should get appealed. But Gautam, the question is, what role IVCA is playing to push the industry view? I'm pretty sure it is obviously within IVCA and within all the members here. But separately, how do you look at IVCA's role for this entire issue?
IVCA has been a very important and driving force. Like I said, my interaction with this industry body over the last 5 or 6 years, uh, uh, one is able to get the industry together and provide a wholesome and a very articulated view to the right forum. And I think that's important. And that's what IVCA can bring to the table. So obviously we are discussing with IVCA on how to take it forward on an industry basis. Some of the points that we spoke about today, there'll be other perspectives, which the regulatory committee will take note of, and then we'll finally decide the course of action.
I just want to add one quick point on this, that IVCA has already taken up the GST issues, some other issues relating to the funds. And one of the specific points I remember talking to the regulators, and that resonated well, that series of discussion happened on, was that why should these expenses be subject to GST? Because if the fund was overseas, then it will qualify as export of service, and why don't you just look at it as a pass-through kind of a thing? So we have already taken up few other issues. We have not taken up, of course, this issue. This decision has just come in, but we have had engagement with the government on some other GST issues in the past.
Yeah. there is a question around mutual funds, saying that is it that this decision will have a bearing on the mutual funds on their expense ratio? Uh, Prima facie, it seems yes, because the answer is at the that they have given a finding that the fund is a service provider. However, the concept of mutuality, one, and the aspect that whether fund is providing a service, these two aspects are very critical and probably stronger in the case of a mutual fund case, especially that there is no class B, class C investors or carried interest in that situation. Hence, there is a stronger defense available for the mutual fund space. But yes, can there be questioning? Can there be litigation? Answer is yes. It can, definitely it can. There are a lot of questions on ge- 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 geographically what is happening in terms of how is this income treated in other jurisdictions in terms of GST or its other implications of income tax. Uh, we'll have to do further research in terms of those jurisdictions. One and two is uh, how is it interpreted in those jurisdictions. We'll have to further research that. Obviously, the representation which IVCA would do or the industry should do is this should cover more and more geographies in terms of how they are treating this subject, so that there is a stronger point to say that even India should be treated on similar to on those lines. uh, there is a question on can we claim expenses too if GST is applicable. So sorry, some questions are not clear in terms of, there are many questions which are in fact not clear in terms of what the precise question is. Someone has asked a question saying that if I invested $1 million and I further invested $10 million and afterwards I ultimately wrote off $10 million, does it mean that GST has to be paid on $10 million? Basically, on the provisioning or the writing down you have done. Now, in this case, when while they were computing the demand, as I just brought out in the beginning, that they have even considered these provisioning amounts or impairment amounts also as a part of the quantification for demand. However, the tribunal has remanded it to the lower authority for recomputation. So we'll have to see how it gets recomputed. In our view, it is in the way the tribunal has given a finding that the retention of contribution to the extent of expenses, it is not an expense, and hence to that extent, even in as per the tribunal decision, just ordinarily should not get covered. However, presently in the computation it is there. So to your question, should there be a GST paid on $10 million? The answer seems no. uh, we have many questions
There's a
but
quick
limited time.
time check.
Gautam,
Yes. A quick
yes,
time
there's
check.
limited time. So I'll just leave a last question, Gautam. It's critical for your, and then you can give your closing remarks. So the question is around this, that, today this is a global issue and everywhere this is a matter of debate, and hence ultimately the governments had to get involved. Somewhere they have given clarification, somewhere they have not given clarification. So the question is that should this subject be taken to a global forum where it can get debated and there could be a kind of similar position globally on this aspect, so that once and for all, like how capital gains is, like how so can this accordingly be get deliberated and then applied globally in the same manner? Your thoughts, and there are more questions too, but limited time. So you can share your thoughts, Gautam, and then we can close on the session.
I think the present focus is just going to be North Block, and let's stop at that. Probably this question is coming in the backdrop of Pillar 1, Pillar 2, and the OECD developments, but I think that's a different concept. So I see one interesting last question. What year does this relate to, and how does this speak about something hitting the fan after, say, X years? Well, as I pointed out, the three things is about the financial impact, the uncertainty, and the retro impact about something happening. And all three, none of them are conducive to our competitiveness in the international forum. So with that, Prateek, Niren, Sameep, thank you so much for educating us and sharing your views, not just the technical analysis of the judgment, but the practical fallouts and as I'll say, from analysis to action, what needs to be done. On behalf of IVCA and almost the 200 attendees that were there this evening, thank you so much. I must thank all the attendees for listening in and raising these questions. I think some of these questions will be good inputs as we work with IVCA to frame the representations as well. So with that, thank you, friends. Stay safe, and we'll be in touch. Bye.
Thank you.
Thank you very much, everybody. Have a great evening.